Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello and welcome to Hull on Estates. You are listening to episode number 711. I'm Stuart Clark.
And I'm Aleida Prinzen.
Aleida, good to be podcasting with you today.
Thank you. Same to you.
I think this is our first time podcasting together, so hopefully it's not too scary and it goes well today. I think we have an interesting topic today to talk about, which is a topic or the case I should say that I recently came across from the Court of Appeal called Jackson and Rosenberg. Citation is 2025 ONCA number 48. And it's an interesting case. I mean, I think for a number of reasons. One, I don't mean this case doesn't reinvent the wheel, but I think it offers an excellent kind of reminder of some of the legal principles that exist in issues like procure and resulting trusts. It kind of takes it from a slightly different angle. And it makes you kind of think through how those legal principles might work in somewhat novel circumstances, we'll call it. And quite interestingly, in this case, so this decision, the 2025 Court of Appeal case, is actually kind of a continuation, we'll call it a reconsideration of a Court of Appeal case from, I think it came out in December, of the same name, Jackson Rosenberg, 2024 ONCA 875, and that is the much more lengthy decision. This one, the parties kind of came back and asked the court, I guess, to reconsider or reconfirm certain issues that kind of came up both before and after their first appeal. So mercifully, the second decision is much shorter than the first one, which is great for me today to podcast about, but also great for anyone who just wants to kind of get a high level summary of what happened. But Aleida, maybe do you want to give us a quick kind of summary of what did happen in Jackson and Rosenberg?
Yeah, for sure. So this case, and I'm looking back a little bit to the initial ONCA decision for the facts here, but it dealt with the transfer of property into a joint tenancy and whether a gift was created or whether it created a presumption of resulting trust in favor of the transferor, and really what the implications of this is on the right of survivorship. So in this case, the appellant, Miss Rosenberg, she was the great niece of the respondent, Mr. Jackson's longtime partner. Mr. Jackson and his partner had mirror wills, and they named each other as beneficiary of their respective estates, and they named Miss Rosenberg as the alternate beneficiary. And so Mr. Jackson and his partner, they owned property together. And on the death of the partner, Mr. Jackson decided to sell the property and use the funds to purchase the second property. Ms. Rosenberg had made no contributions to the purchase price or the maintenance of this property. It was solely in Mr. Jackson's name. He used his own funds to purchase it. Ms. Rosenberg never lived there. But then in 2012, Mr. Jackson decided to transfer the property to himself and Ms. Rosenberg as joint tenants with the right of survivorship. And so the idea behind this was to avoid probate fees on his death because he wanted to transfer everything to Ms. Rosenberg eventually. And this was a way to avoid any probate implications from that. Years later, however, in 2020, Mr. Jackson decided to sever the joint tenancy after he became concerned with Ms. Rosenberg's plans for the property while he was still alive. And so thereafter, the title was held as tenants in common between the two parties. And so he had claimed that his intent in putting her on title in a joint tenancy was, as I said, to avoid probate fees on his death, and that whatever equity remained in the property would have passed on to her in accordance with the will. And so he argued that her portion was held on resulting trust. She, however, claimed that it was a gift and that it came with the full beneficial rights and interests that come with joint tenancy, including her ability to encumber or sell the property and essentially exercise those rights while Mr. Jackson was still alive.
Exactly. No, thank you, Aleida. No, so it's an interesting one, right? So this case is kind of it's a slight twist on the classic procure example. And for those who don't know the procure case maybe as well as us estate lawyers do all the time, procure is a case that gets cited all the time. It's Supreme Court of Canada decision. I think it's from 2007, but it itself only reaffirmed a long line of cases that came before it, with the basic principle being that, when an adult transfers title, typically real property, although there were some cases that followed that also dealt with bank accounts, into joint ownership, typically with an adult child of theirs. There is a presumption that that adult child is, when the parent passes away, doesn't get the right of survivorship on that property. There's a presumption that they are holding that property on a resulting trust for the benefit of their parents' estate, or for the original owner's estate. That principle itself is a rebuttable presumption. So if you can show evidence that no mom, dad, in this instance, great uncle, spouse, whatever it is, intended for me to get that property, you can rebut the presumption, and you can still have the property past your right of survivorship. But in the absence of evidence to rebut that presumption, it is assumed that you, surviving joint owner, hold that property in trust on a resulting trust for the benefit of the deceased original owner's estate. Classic Pecora comes up all the time. We see it cited frequently, in cases that we deal with, but this generally a lot in estates matters where, because joint ownership is a fairly common thing that happens between parents and children. Typically, these fights happen after the death of the joint owner, the original joint owner, right? Where, other beneficiaries, other siblings, someone says, hey, wait a second, mom, dad, great uncle, didn't mean for you to get that. You need to give it back to us and we get a chunk of that too. And then it's all sorts of, well, how do you prove it? What evidence can you get about intention? Blah, blah, blah. That's not for today's podcast. Jackson Rosenberg is neat, though, or a little bit, maybe neat's a relative term, but it's a slight different twist on it because the person's still alive, right? I mean, in this instance, we have the original joint owner saying, wait, give it back, I want it back. And then even went to the extreme example, while it's still alive, of severing that title, right? This isn't a scenario now where they're just both on there as joint tenants with survivorship. They said, no, I'm severing title. I own my 50%, you own your 50% as tenants in common. And then went a step further with this reconsideration decision, which said, and I want your 50% back. So not only did I sever title, so this is now mine, but the part that you still own, which in theory is now 100% owned, well, your 50% is only owned by you. If tenancy in common is to be believed, this isn't a joint tenancy, hey, we kind of own this together situation anymore. What's yours is yours and mine is mine. In theory, well, you're saying, well, actually, I still have my Pecora resulting trust argument over that 50%, and I want that money back, or I want that property back. And here the Court of Appeal says, yeah, you do, right? So your 50% that you severed is yours outright, that is yours. But that other 50% is still held on a Pecora analysis, even though the title was severed. And we are going to order a vesting order in this instance requiring Transferor E to give it back to the original person. So it's now the original owner is 100% again. And it's neat, right? Because it's all based on a Pecora analysis. Pecora shows up throughout even this, it's a relatively short decision. I think it's only, 12 paragraphs long, but Pecora is there, at the end, showing its face to say, yes, that, you have to return it. And it's interesting that the very fact that the original owner just asked for it back, the court says, is enough for you to be required to return it to them, right? Reading here from the decision, Mr. Jackson, as the beneficiary resulting trust over the 50% share in the property held in Mr. Rosenberg's name, is entitled to demand that she comply with her duties as trustee. It is the very essence of the duty of the person holding property on resulting trust to return legal title to the original owner. So it's that simple, right? So, I mean, the 50% is owned on a resulting trust by the person for the benefit of the original owner. I want it back, give it back. And they had to. So I think it's interesting.
Yeah, no, definitely. And I think what's really interesting as well is the conversation about the right of survivorship in relation to that as well, because the application judge initially concluded that Ms. Rosenberg still had her right of survivorship with respect to 50% of the property because she was still, a tenant in common. But the Court of Appeal, they said, no, there's no right of survivorship when it comes to tenant in common. That's something that's unique to a joint tenancy. And when Mr. Jackson, severed it, which he had the right to do unilaterally, that also extinguished any right of survivorship that Ms. Rosenberg might have had.
No, exactly. That's interesting, right? So, I mean, so where does this leave us, I guess, if you're trying to give advice to, someone comes into your office, still alive, hopefully not a ghost coming into your office, and says, hey, I'm so upset with myself. I transferred my title, my property into joint ownership with my kid, my niece, my whoever, and I want it back. I don't want them on there anymore. How can I make them give it back to me? I mean, this case kind of gives you somewhat of a path through it. I mean, I suppose at its core, if you're arguing that the interest is only ever on a resulting trust, I don't know if the severance of title is necessarily required before you could go to the court saying, hey, give me back my, I want you off title and I want this me alone. But this case also says there is a path through this where you could sever title, right? Maybe the severance, I suppose, at minimum ensures your estate has that 50% interest, and then you're only arguing over the other 50% interest that's still held by the other person's name. And in this instance, if you can say, hey, they're holding this on a resulting trust for me and I want it back. Well, this case seems to suggest that statement alone, if taken as gospel that you want it back, should be enough for them to have to give it back and you can get your property back. So maybe there is a path through. So if that person comes to your office saying, oh my gosh, I made the biggest mistake of my life. I want my property back. There could be a way to get it back either by severing and saying, hey, give it back, or maybe even just going to court saying, hey, I want them off here. They're only ever on here on a resulting trust argument anyway. And the court says they got to give it back to me, so give it back to me.
Yeah, no, absolutely. It's interesting. And I think it really highlights, even before all of that, when you say, you're going to your lawyer and saying, I want to put this person on my property, on title for, whatever reason. I think the importance of intention is really highlighted here because in the decision, they noted that Mr. Jackson had said that the lawyer who did the transfer did not really explain the implications of this transfer to him. They didn't say that there could be issues with, Ms. Rosenberg's potential rights during his lifetime. And he had, done the transfer with the expectation that her rights would only kick in on his death.
No, I think that's an important distinction too, right? Because I think, this case doesn't get into that level of analysis here that sometimes you see. But there are cases out there that point to when you're dealing with a PCOR analysis post-death, it's intention at time of transfer that matters, right? People can change their intentions after the fact. But What was the intention when you actually put the person on title? Did you, mean to gift them the right of survivorship? Or did you mean to have this PCOR resulting trust type relationship where you're only doing it for convenience sake or whatever it is? It would be interesting to see if the evidence showed that when this transfer happened or in a similar situation, if the actual, if the court found the intention was to gift and they, without the, or with the right of survivorship, if you could then walk that back using the severance, give it back analysis. I have my questions if that was what the evidence and conclusions came to. But at least in this instance where the evidence seems to suggest, I guess, that the omission of evidence is itself the presumption, right? Because obviously in the lack of evidence, the presumption is that you're holding it on resulting trust. So in that scenario, it seems to be the path is, well, you can sever and ask for your 50% back or the other 50% back. But yeah, the door is open, I suppose, a little bit to a scenario where the evidence was, no, when I put them on there, it was for, I want to gift this to them. And now I've changed my mind and I want it back. Could you do that? Answer is, I don't know. I would have questions. I can see why maybe the argument could be you can't ask for it back in that scenario. That's not this scenario. This is a classic PCOR, lack of evidence to the contrary, and therefore resulting trust. Give it back.
Yep.
But yeah,
yep,
interesting.
Absolutely. Yeah, absolutely. And it reaffirms, that joint tenants, they do have that right to unilaterally sever, and they can do that at any time.
Exactly right. Yeah. So the case doesn't necessarily reinvent the wheel, but it kind of makes you look at some of these issues from a slightly different perspective, and also offers some interesting kind of options, I suppose, to a still alive person who says, "Oops, I didn't mean to do that. Can I have that back, please?" And here the Court of Appeal says, "Yep, you can." And the core, resulting trust argument just says, if you as the beneficial owner of a resulting trust says, "I want it back," the trustee on that resulting trust has to give it back to you. So interesting case, but Jackson, Rosenberg, 2025 ONCA number 48. So for those out there, read away. But yeah, no, I think that brings us to an end of our podcast today. It's been a pleasure podcasting with you today, Aleida, and hopefully we can do it again soon. So until next time, I'm Stuart Clark,
and I'm Aleida Prinzen,
and thank you for listening.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.